Welcome back and good morning, everyone. My name is Lindsay Kara Stencil, and I'm a partner in the New Ventures Practice Group here. And today on Startups Streamlined, I am joined by Carrie Shufflebarger, who is a partner in our Intellectual Property Practice Group. Because as we're going to discuss here today, things like trademark, copyright, trade name, that is all intellectual property, and we need to think about each and every day how we're going to protect some of the assets that we've worked hard to develop. So today we're going to discuss why trademarks and brand names can be extremely valuable assets to your business. And oftentimes trademark or a brand name becomes just as important as the product or service that we're selling each and every day. In this session, we're going to explore the fundamentals of the various types of intellectual property and protection thereof, and how we can use those things to maximize the growth and value of our businesses. So we're also going to examine third-party intellectual property rights and how we can avoid some of those pesky infringement issues and avoid getting those scary cease and desist letters. So if you have questions, comments, as we're rolling through this, please drop those into the chat. We monitor those as we go along, and we do our best to either ask them if they fit in right now or ask them at the tail end. If we miss any questions along the way, we will follow up with you afterwards. So without further ado, let's go ahead and get started. Carrie, welcome to Startups Streamlined. We're so lucky to have you here. Can you just give us a quick 20-second overview of what you do every day in your bio?
Sure. My name is Carrie Shufflebarger. I'm an attorney in the Cincinnati office. I do trademark and copyright, prosecution and litigation, a little bit of everything. I am not a patent attorney. I have litigated patents in the past, but I've retired from that and focused my practice almost exclusively on copyright and trademark, not only protection and enforcement, but I also help Lindsay and their team both in those areas, and also when you get to the point of transactions and acquisition by other companies, I help in the diligence for that as well.
Yes, and Carrie is a huge asset to our team. I can't tell you how many times I have to say, Carrie, can you please help me with this and this IP related matter? So, okay, why don't we start from the foundational point? Can you tell us the difference between a trademark and a trade name so that the folks out there can understand that?
Sure. Trademarks and trade names can be the same thing, but don't necessarily need to be the same thing. Your trade name is what Lindsay and her team is going to help you with to organize so you can do business and file with your secretaries of state to be authorized to conduct business. The trademark is consumer facing. That's your source identifier for whatever good or service you're offering. A good way to look at that is your trade name is what you're going to put on your contracts with your lenders and folks in those areas. The trademark is going to be more to your customers. An example I like to use from where I live, there's a McDonald's franchisee. Obviously, the trademark is McDonald's, but the trade name they have is Golden Archways LLC or Inc. So that's their trade name. So they can be similar, the same, but they serve different functions in your business needs.
Awesome. Okay, and so then the next question from that logically comes, okay, we hear about copyright and we hear about trademark. What's the difference between those, and what is copyright?
Sure. Intellectual property is a funny thing because more than one type of intellectual property can protect the same thing. Trademark, like I said, is your brand. It's a source identifier. Copyright protects original works of authorship fixed in a tangible medium, and those can be text, images, play, choreography, anything creative. So for example, when I say that more than one type of intellectual property can cover a single thing, let's say that you commission the design of a very intricate logo that's going to be part of your brand. That artwork can be both a trademark and as well as you can secure copyright protection for that logo. Something to keep in mind with with copyright in particular, copyright rights, they exist at the time you fix that in a tangible medium. A registration is not required for you to own a copyright, but registering a copyright is relatively inexpensive and it gives you additional remedies. And if you ever want to sue somebody, that's your ticket into court. Flipping gears to the trademark, trademark rights, you accrue trademark rights from you using it in commerce. Again, you don't have to have a registration, a federal piece of paper to have trademark rights, but there are a number of benefits for securing the registration and the protection. So we always suggest that you do so to maximize the rights in your brand. But say that you are starting to use your mark right now. You want to claim proprietary rights in that, but you don't have a registration yet. We strongly advise that you use the little superscript TM by whatever you're claiming as your trademark to put the world on notice that that's your brand.
Yes, exactly. And so what types of intellectual property protection then are really important for particularly our startup founders to be thinking about each and every day?
Sure. Well, it depends on the nature of the startup, obviously. Several of the clients in this space that we've had do have patent concerns, and we have a patent team here who can help you with that. My job is to get you to those people because I am not that person. The second thing is obviously your brand, your trademark. You want to, as soon as to your earlier question, Lindsay, when's the appropriate timing? It's now. Even before you officially launched, we recommend that you decide on your branding, do a clearance search to make sure you're not going to be trampling on anyone else's rights and get one of those nasty gram letters down the road. Copyright, like I said, anything that's fixed in a tangible medium, anything that you have in connection with your business, we recommend putting an R in the circle with it, which designates that's a register, or excuse me, not R in a circle, I misspoke, the C in the circle, which is the copyright signal to the world. Trade secrets. I believe our startup team has a suite of documents that probably take a lot of that into account on the employment side. That's a little bit out of my lane, but that's something that our corporate people help you with on the front end. Also, with respect to intellectual property that you want to use in your business, you may not own all of it. So you're going to want to make sure that you have secured any additional rights that you may need. And a good tool for that is just the basic, the contract. Several examples of that. For example, you commission a third party to design your logo that's going to be your brand. Just because you use it as a trademark doesn't necessarily mean that you own the copyright in that creation. If you use your employees by operation of law, you would own that artwork if it was within the scope of their employment. But if you use a third-party contractor to design that, you're going to want to lock in the transfer of the necessary rights in that artwork to you, because the artist, the author, owns that if they are not an employee of you.
So I would tell you this is probably one of the areas that causes the most consternation, particularly as we start to roll into taking on more funding or exiting a business, because investor or buyer always wants to know, hey, do you own the rights to the things that you say that you own? And so without giving up any client confidences, do you have any nightmarish war stories of, because I know I do, but where you come to find out in the 11th hour that a client maybe didn't include some of the work for higher language, assigning copyright and all the other intellectual property rights over to a company, and then it's sort of holding up the transaction. So I'm sort of curious if you've got any tales from times past.
You probably in the transactional sphere have more than me, but I can tell you that there's a fair amount of cleanup that goes on before those deals can close. It's tracking down the folks that you need to assign those rights and make sure they, as the artist, still have the rights they need. For example, a lot of times artists want to use have the rights to use it as part of their portfolio. It is just easier to take care of that at creation than track it down down the road. Uh, this isn't really responsive to your question, but something I see not only from startups but from large companies as well is not getting appropriate licenses for photographs to use on social media, in on their websites, in any forum. And there is a bar out there of lawyers who their only offering is, what I call the copyright trolls. You could have licensed this picture for $500, but since you didn't and you used it in a commercial fashion, they want you to pay $10,000 to settle the case before they bring it. And this isn't something that just, like I said, small companies fall into this trap. I settled one earlier this year that was a very large company that had used a photo in a marketing slideshow. And it cost them dearly just because they had not adequately trained their people that things you can right click on the internet are not free. So that's where you can fall in trouble using third-party content that you don't even think about, because we all can, we learned to right click in college or whenever, wherever we were in our development when the internet came about.
Yeah, and isn't that so true? And I think for our large corporate friends that I can see out there listening today, it's almost a bigger risk to them because they have deeper pockets that, some of these copyright and trademark, et cetera, trolls want to hunt down and tap into. So certainly worth doing the training. And I know I've worked with folks in the intellectual property team to do trainings like that for not only our startup clients, but some of our larger corporate clients. So naturally, if that's something that you're thinking about or you're not sure if you're covering it the right way, reach out to, Carrie and her team. They can certainly be helpful there. So now we talked about, making sure that we get some of that IP assigned. So what are now some of the risks that startups have to think about when it comes to using third-party intellectual property? What do you see there in terms of licenses that are needed or rights that are needed to make sure that companies, when they are using someone else's work, that they are not running into just a world of hurt?
Well, the first thing is be cognizant of the work for hire doctrine, which I'd already mentioned. If someone who is not your employee is creating content for you, make sure that it's appropriately assigned. To the extent you're using images or other third-party material, look into licensing for it, because I can tell you that a license is going to be a lot cheaper than a claim for unlicensed use. This applies to photos, to music, to any kind of content that you are integrating into your business. And this includes not only directly, but your advertising. If you're at a trade show and you're running a booth with music, there's all kinds of areas where you can get in trouble. Other areas of third-party content that you can use and to keep in mind. One, if it's in the public domain, it's fine to use. We can help you figure out if it's in the public domain, but more likely than not, it's not. Two, like I said, get a license. It's cheaper than the claim of infringement. A lot of times clients of all levels ask about fair use, and everyone likes to think that their use is fair use, but fair use is a very gray area, and it's always in the eye of the beholder. And here, the eye of the beholder is the judge who's assessing your claim. So keep that in mind. The four fair use factors are the nature and purpose of the use, the amount taken, if you're affecting the market for it, and I'm blanking on the fourth one, but the long and short of it is, if you're using it for a commercial purpose, it's probably going to be difficult for you to claim that it's fair use. So it's always a risk when you're using third-party content.
100%. And so that goes for our nonprofit holders too. Remember to make sure, just because you maybe aren't turning a true profit, if you're somehow commercially benefiting from it, i.e. getting grant dollars or otherwise, this could also be something that is impactful to you. And so I always have to flag too. I see a lot of decks. I see roughly 1,000 pitch decks a year from my fund clients, from my startup clients, and the name of the game a lot of times is listing logos. Like, how many logos do you have from different investors or different vendors or customers? And right. All of that requires approval. You can't just use someone else's logo or trademark on your deck because it makes you feel good and you like the colors. You have to get the approval. So if someone's going to be using, Thompson Hine's logo on their deck, what do they need to do to get an approval for something like that?
Well, first thing, I would check, where are you getting the picture from? Are you lifting it from their website? Go to the terms and conditions of the websites. Oftentimes, there is some language, some guiding language in there. The second thing is, see if there's any link to how you get permission, either on their website or just ask the question. To the extent you're talking about logos, that's kind of another gray area, because what clients want to say is, well, this is fair use. This is nominative fair use. How am I supposed to say that Thompson Hine is my legal counsel if I don't put Thompson Hine in my slide deck? And the response to that is, to say it's nominative fair use in that manner, one of the factors is you've used only the minimum amount that you need to make that statement. And so with the logos, do you really need to use the logo to say Thompson Hine? So it would absolutely be fair use for you to say Thompson Hine, Jones Day, and Greenberg Traurig are my legal counsel. But when you use the logos, it gets into a little messier of an issue. Now, granted, you still have the defense of, is this really a trademark use? Because you're not really advertising a good and service with it. You're just saying, hey, this is my counsel. But if you want to take the safest route, it's always just list the names and not use the logos unless you have specific permission from the owner of those trademark rights.
Right. And I always encourage the clients to take a look at your agreements that you have with customers, vendors, investors, and make sure they didn't say you cannot use our logo or anything related to our business without our explicit permission, because that's a quick and dirty way to get in trouble.
Absolutely. And some of those contracts may say you cannot identify us as a service provider, or even say that you're affiliated with them in any way, because it suggests authorization. Absolutely, read contracts is the first place to look if you have an existing relationship with someone.
Lawyers are the killers of fun, right? Because that is an exciting thing that you do want to talk about as a startup, as a large company, saying, hey, we have all of these great clients or these great investors, and then your lawyers come in and say, well, you need to get permission. And I know that feels like a headache, but it's better to communicate that stuff out with your customers, et cetera, than it is to fly by the seat of your pants and get yourself in trouble. So
sure, that's what they teach us in law school. Our job is to be a buzzkill to the marketing people in any business.
We are the worst. We are the worst. So, okay, as we're heading into the tail end here, what are some of the best practices to ensure robust intellectual property protection for not just startups, but the larger corporates as well? What do you see as some of the best practices? Is it trainings? Is it documentation? What is it? You tell us.
Sure. A lot of times, and understandably, with the first round of funding, and you're trying to get off the ground, intellectual property is depending on the nature of your business, not always the first thing you think of. But I would recommend deciding on a brand early. Invest the money on a clearance search to make sure that somebody else is not already using your mark or something similar in the particular field that you're in. And if you are wedded to something and you are locked in, that's going to be your brand, file it, even if you're not launched yet, because you can trademark rights. You can file what's called an intent to use application. And what that means is you may not be using it yet, but you have an intent to. And when you file that application, it gives you a presumptive nationwide priority date of that filing date, even if the registration doesn't issue for 3 more years. For example, if you file an application today on May 24th, 2022, saying you had an intent to use this mark with widgets, that would give you priority over anyone who use that same mark with widgets after that date of priority once the registration issues. So it benefits you to decide early, make sure you're not stepping on anyone else's toes, and kind of get ahead of it on that. Use the marks consistently. If you are claiming trademark rights, use the little TM superscript so the world knows that you're claiming trademark rights on that. Trademarks are adjectives. Always use them correctly. Google notwithstanding, because that's a separate issue altogether, and you're not Google and probably won't be for several years. Do not use your brand as a noun, because it weakens the scope of rights you have. And just keep in mind, it's always an adjective, like Nike shoes, Delta Airlines. Don't use it, because what you do is if you're using it as a noun, you risk it becoming generic for the genus of product or service that you're offering. When choosing a trademark, and this gets back to the marketing lawyer dichotomy, marketing always wants something clever and descriptive to describe what your services are. But descriptive marks are really not that strong of trademarks, because other people need to be able to describe a competing product using that same description. The best trademarks are marks that are coined terms or that are completely arbitrary for whatever services you're offering. And obviously the prime example of that is Amazon for what used to be book sales, and now it's everything.
Everything sales, literally everything. Okay.
Oh, go ahead.
No, keep rocking and rolling if you've got more. I love this because I think it's super helpful.
That's probably like I said, use it consistently. Police the marketplace for other folks who may be misusing your brand. And the simplest and easiest hack on that one is set up a Google News alert. Put your name or your brand or whatever in a Google News alert, and so whenever somebody's mentioning you out there, you'll get notice of it. And that's a trade secret here, but it's a cheap giveaway that you don't need a lawyer to do that for you.
Sure. So things you might need a lawyer for. What do you do when you get a cease and desist letter because maybe someone is accusing you of encroaching on their trade name or their trademark or their copyright? What should those people do?
Call me. Send me the letter. Don't concede anything or even send a letter, anything like that, because it's a more nuanced question than perhaps the trademark owner who's sending the nasty letter even may think. If, for example, trademark rights accrue from priority, if you may have been the first to use it. So somebody may be sending you a letter saying, hey, you're infringing my rights, and you may have been first. So always investigate, call us to investigate, and then we can make the best case for it. Oftentimes, depending on the nature of it, a simple pick up the phone from one lawyer to another can work it out faster than engaging in a battle of letters that are just, chest thumping in nature. It's really fact specific of what's the claim and who's it from. For example, you're going to treat, say you're making telephone cases that you're selling on Amazon. If a complaint's coming from OtterBox, you want to take it more seriously than if the complaint's coming from random maker of phone cases in California, because there's different levels of escalation that particular companies will take if they think their rights are being infringed. I'm not saying you always have to roll over for the big behemoth, but that's just kind of an example that came to my mind of people who are more litigious for their brands.
Right, totally understand that. And so I know you mentioned, hey, you have a duty to sort of protect your trademark. What happens if you're just running your business and you're not really running those Google searches to figure out if someone's encroaching on your brand or something, or using your name to do things? What could result if you don't take the necessary steps to protect that intellectual property?
Sure. Trademark owners are charged with a duty to police against misuse of their brand. It's an affirmative duty. And to the earlier point, you run the risk of abandoning your rights because you've allowed it to become generic or widespread use by third parties in a manner that degrades your trademark rights. So don't look at it as always being a bully. Sometimes you just want to make sure that it's used correctly, and not in a way that diminishes the value of your brand. And to your earlier point, where that comes up is when it comes time to either get more funding or a larger company comes along and wants to acquire the gem that you've created.
Right. Yeah. And that can be super tricky. So lastly, I'm going to ask this question because I know I get this so many times. When you go to file a trademark, particularly a trademark, you file it with the US Patent and Trademark Office, and really, we don't hear anything for a very long time. However, we all get these random mailers that are like, send me $1,400 to protect your things, and they look very official. What should people do with those?
File them in the circular file that's by your feet under your desk right now. Or if you're really concerned, send it to us and we can check. Or the USPTO actually has a warning on their website where they list some of these companies. Here's something to keep in mind. There's not a trademark office in Philadelphia that you owe money to, or Hungary, or any of these places that the return addresses are on. The United States Patent and Trademark Office is in Northern Virginia, and if you've used a law firm to file your application, those communications would come to us, the lawyers, not you, the client. So 99.99% of the time, if you get communications like that, they are fraudulent. If you file your own trademark application, it's possible, but now all communications are electronic from the trademark office. If you get something in the mail, it is not about a United States application. It is not legitimate.
Right. And so if you are one of the people who are looking to protect your name internationally, which is a whole other bucket of things that we didn't get into today, and you start to get these mailers, make sure that you reach out to your counsel to ensure that you're not either just sending some rando a bunch of money that you don't need to, or you are not waiving or losing some rights related there too. So ooh, that was a lot, and that was awesome. So I do very much appreciate it. So that concludes today's discussion. If you have any other questions, I know we're running up on time, please drop those into the chat and we will make sure to circle back with you and get you some answers there. But this webinar was recorded and will be available on our Thompson Hine YouTube channel. So don't forget to hit like, subscribe, and ring that bell. We always appreciate that. And of course, most importantly, we want to thank you, Carrie, for sharing your wealth of knowledge today on trademarks, trade names, and the things that our client companies always need to be thinking about. So at the end of this, you'll be prompted to take a quick survey. Listeners out there, just a couple quick questions. please do us a favor and answer those so we can continue to produce awesome content. And again, Carrie, thank you. You're fabulous.
You're welcome.
And I appreciate you.
Thanks.
Thanks, everyone.